My name is Billy Counterman. Between 2014 and 2016, I sent hundreds of Facebook messages to CW, a local musician. When she did not respond, I sent more aggressive messages, such as F off permanently and die, don't need you. I have been diagnosed with a mental illness and was seeing a therapist at the time.
My name is CW. Counterman's repeated, often aggressive messages have upended my daily life. Counterman was rightfully charged under a Colorado statute making it unlawful to repeatedly communicate with another person in a way that would cause a reasonable person to suffer serious emotional distress and does cause that person to suffer such distress.
But what about my First Amendment right to free speech?
Great question. The question we will rule on today is whether to establish that a statement is a true threat unprotected by the First Amendment. The government must show that the speaker subjectively knew or intended the threatening nature of the statement. And our answer is yes.
We concur.
We dissent.
What? How did you make that decision?
Well, everyone agrees that true threats of violence are not protected by the First Amendment, but were Counterman's messages a true threat? We believe that, for a statement to be a true threat unprotected by the First Amendment, the defendant must have some subjective awareness of the threatening nature of the statement. This is because an objective standard would chill too much speech, as people would be afraid of accidentally making statements that could be interpreted as threatening. For the same reason, other categories of unprotected speech such as defamation, obscenity, and incitement to unlawful conduct require the speaker to have some level of awareness for the speech to be punished. But what type of subjective standard does the First Amendment require? Must the speaker act with purpose, with knowledge, or only with recklessness? We believe that the correct standard is recklessness. A person acts recklessly when they consciously disregard a substantial risk that their conduct will cause harm to another. A recklessness standard is appropriate because it strikes the right balance between not chilling protected speech and making sure that true threats can be effectively prosecuted. Because Counterman was prosecuted under an objective standard, not a subjective recklessness standard, his First Amendment rights were violated.
I concur in part and concur in the judgment. I agree that a subjective standard is required in true threat cases. I also agree that in this case, recklessness is a sufficient standard. However, I do not believe the court should rule on whether recklessness is sufficient for all true threat cases. True threat doctrine applies only to pure speech, which this case does not involve. Instead, it involves the conduct of stalking, including but not limited to threatening statements. This kind of prosecution raises fewer First Amendment concerns.
I agree with most of that.
I dissent. Nearly every other category of unprotected speech can be restricted using an objective standard, including fighting words, false, deceptive, or misleading commercial speech, obscenity, contrary to what the majority says, and defamation against a private person. Why should true threats be different? And even if we did require a subjective test, why recklessness? That standard is grounded not in law, but in a Goldilocks judgment. Not too much, not too little, but just right.
I join your dissent in full. I would also like to add that the majority should not have cited New York Times Company v. Sullivan when discussing defamation, because that was a policy-driven decision masquerading as constitutional law. We should reconsider our defamation jurisprudence, not apply it to true threats.
You are both wrong. Counterman's First Amendment rights were violated because he was prosecuted under an objective standard when a subjective standard of recklessness was needed. Therefore, we vacate the judgment of the court below and remand the case for further proceedings not inconsistent with this opinion.
You rule, Supreme Court.
You suck, Supreme Court.